Welcome, everybody, to another episode of the SERMAPod. I am your guest host today, Matt Liller, and I am very pleased to have an awesome guest with us today of Eric Cramer. Now, Eric is the chairman of Berger Montague, which is one of the oldest and most respected complex litigation law firms in the United States. He co-chairs the firm's antitrust department and leads multiple antitrust class actions around the United States, including not one but two that we are going to talk today. Welcome, Eric.
Thank you for having me. Appreciate it.
So, Eric, today we're going to talk about the antitrust case, or rather antitrust cases, against the UFC. So I'm going to hand the proverbial ball to you and let you walk us through the origins of the lawsuit, or at least the first lawsuit, and what motivated fighters to take legal action against the UFC back in 2014.
Sure. So we were approached by a group of fighters who were dissatisfied with the way that the sport of mixed martial arts was being organized and run. Effectively, in or about 2013, 2014, you had one organization that basically controlled an entire sport. They controlled the titles, the only titles that mattered, the only championships that mattered. They controlled who would fight for that title, and they promoted both sides of every fight. So unlike other sports where one team owned by one person will play against another team owned by another person, or in boxing where each side is promoted by a different promoter, in mixed martial arts with the UFC, you had one promoter controlling the only titles that matter, deciding who fought whom, and promoting both sides of every fight, and then also being the only place where a top level mixed martial arts fighter could fight. So, and as a result of that situation, the UFC was able to suppress the pay of the fighters below any level that was fair or competitive. So in the UFC, the percentage of the wages that the fighters were getting was well below, significantly below 20%, whereas in baseball or basketball or football or hockey, it's 50% or more. And in boxing, it's 60, 70, or 80% go to the athletes of the money that's being taken in by the sport. UFC, you had much less than that. So the group of fighters was frustrated and unhappy with that situation. And because they are treated as independent contractors and not employees, they can't organize as a union. Their main avenue for relief is antitrust. They came to us, we investigated the case, and then we brought the case in December 2014, challenging the UFC as what's called a monopsony, which is like a monopoly, but for buyers of services. We claim that the UFC was a monopsony buyer of the services of top-level mixed martial arts fighters, and the case went on from there. Effectively, what the UFC did, and the reason why we brought the case is because their structure controlled the entire sport. They signed up all the fighters to long-term exclusive contracts, similar in some ways to the reserve clause in baseball that didn't allow players to get traded from team to team. So that's why we brought the case, and we've been litigating it ever since.
Eric, I do have to admit that I had to Google the word monopsony in preparation for today's podcast. So you mentioned that this lawsuit was filed back in December of 2014, and here we are in 2024 talking about a recent court approval of a settlement. So what are some of the primary legal hurdles and complexities that contributed to such an extended time frame?
Yes, so there were a number of different things that contributed to the 10-year battle in this case. Number one, antitrust class actions do tend to take longer than a lot of other cases. They are complicated cases to prove. They take a long time to gather the information necessary to prove what you need to prove to win your case. You need to work with economists and other experts to analyze the data and determine whether your clients and the members of the class were impacted and injured by the conduct, and by how much. And all of that takes a lot of time in just about every antitrust class action. In this one in particular, there were some additional hurdles that we had to fight and deal with. Number one was that the UFC, Zuffa, the company that owned the UFC, had a document destruction policy that it destroyed all of its documents after 90 days. So we had to find other ways to find the documents we needed to prove our case. and we were able to find other ways to do that, but that took time. Also, the case is about what we allege is a scheme of anti-competitive conduct that harmed the UFC's rivals and allowed the UFC to control the market that went from about 2005 all the way to 2017, and beyond. So it was a long period of time that we needed to evaluate. We needed to look at the evidence each year and over time and evaluate the whether the conduct occurred, what the conduct was, and what the effects of that conduct was on the market and on the fighters. And all of that took time. So it was just a long process. And we also had COVID in between, which slowed us down, and some other factors that slowed us down as well that we can get into.
Well, Eric, in the original filing, the claims were that exclusive contracts, coercion, and UFC acquisitions were part of the UFC's strategy. So how did you and your team go about, proving or working up these claims, and what were some of the counter arguments that you were seeing from the other side?
So we alleged essentially that the UFC, through this scheme, gained control of the market for elite mixed martial arts fighter services. And the scheme, as you just identified, involved basically three prongs. Number one, they signed up all of the athletes to long-term exclusive contracts. And we allege that through various provisions in those contracts, they effectively lasted for as long as the UFC wanted them to last. They went on, they could be renewed, and it was very difficult for the fighters ever to get out of them. Second, we allege that the UFC, in addition to locking up all of the top fighters into long-term exclusive contracts, bought out rival after rival after rival. So every time another promotion that started to compete with the UFC rose up, the UFC would buy it out, shut it down, and take all their fighters into the UFC. And then finally, coercion. We allege that the UFC used a lot of different tactics to force the fighters, even if they could fight out the end of their contract, to have to re-up and re-sign with the UFC, such that at one point the UFC basically controlled 80 to 90% or more of the top level MMA fighters. And given that it's a sport where, in order to advance in the sport, you need to fight other top level fighters, and given that the UFC would not promote their fighters against the fighters from another promotion, they made it such that there was nowhere else to go. If you want to advance in the career, you had to go to the UFC. If you wanted to get a title that mattered, a championship, you had to go to the UFC. And this was because they executed a strategy borrowed in part from championship boxing in the 40s and 50s, which was found illegal by the Supreme Court of the United States. They engaged in that strategy, and then they took over the sport. And so we had to go about proving all of that. We needed to get all of the contracts that the UFC had with all of their fighters over the entire 2005 to 2017 period and analyze those contracts. We needed to figure out how they worked. We needed to analyze each of the UFC's mergers and buyouts with other promoters. We needed to take the depositions of the people involved in that and get the underlying documents from that. And then we needed to look at how the UFC operated to coerce fighters into never leaving the UFC. So all of that involved extensive document discovery, many depositions, documents produced not just from the UFC, but from many other promoters and from boxing and from other sports, so that we can analyze and understand, and our experts can analyze and understand the industry and how it functioned, and how the UFC used this scheme to dominate the sport and then suppress the pay of the fighters.
So moving a little bit from the meat and the potatoes of the claims to the recent approval of the settlement, the publicly available information and articles say that this settlement would lead to several hundred fighters receiving life-changing money as a result of the settlement. But as I understand it, the amounts, these payout amounts can differ fairly vastly between the fighters. Can you provide us with some details on how these payouts are structured, and what decision criteria might be used to see who might benefit the most from the settlement?
Sure. So it's a $375 million settlement. Right now, the court has preliminarily approved the settlement, so there's a little bit more process before it's final approved. The class members will all get notice very soon about the settlement if they don't have it already, and they'll have an opportunity to weigh in about the settlement. And then, at that point, there will be a final approval hearing in February where the court will finally decide whether to approve it or not. If the court approves it, then we're into this allocation plan or program that you just asked about. So here's how the money will be distributed to the fighters. It'll basically be in proportion to two different factors. Number one, how many bouts those fighters fought during the class period, which goes from December 2010 to June 30th, 2017, and how much money they made during that period. So the more you made during the period of it's called the class period, the more you'll get. The more you fought during the period, the more you'll get. And then there's a minimum amount. Everyone will get at least $15,000, and some will get well more than $1 million. And it varies. If you fought once and you never fought again, you'll get less than if you fought 10 times and made a lot of money but should have made more.
So, Eric, a number of professional fighters have reported that the UFC has had a pretty significant influence on career choices that they've made. Do you foresee this settlement altering kind of the balance of power between UFC and its fighters going forward?
I don't think this settlement will do that. I think this settlement is mainly about achieving money and recompense for underpaying the fighters as a result of what we allege were the UFC's anti-competitive and illegal conduct in violation of the antitrust laws. And I think we'll be talking about this, we have a second case called the Johnson case. And that case is seeking not just money, but also prospective relief or injunctive relief to try to change the UFC's business practices. In the end, the first case did not do that because it only went through 2017. And it's hard to argue to a court that they should change the business practices of a company in 2024 based on evidence that you have through 2016 or 2017. But the Johnson case now is currently being litigated, and that is a case where we are seeking the changes to the UFC's business practices to create more competition in the market for mixed martial arts so that fighters will have more options and be able to make more money with their careers.
Yeah, and that's a perfect segue because I did want to talk about the second suit, which I know is ongoing, and so you've got some bootstraps on what you may be able to talk about today as far as the second suit. But how does it differ in terms of the claims that are being asserted?
The claims are essentially the same. We allege that the UFC continued to engage in the same conduct and that same conduct is continuing to have bad effects over time, that the mergers, the coercion, the contracts that they have with the fighters is continuing to allow the UFC to dominate the market for mixed martial arts fighters and suppress the pay of the fighters. And so it's essentially the same claims, the same scheme that we allege the UFC is continuing from the end of the class period of the first case called the Lee case after Kung Lee, into the Johnson case after Cage and Johnson, 2017 to the present. But we've just started getting documents in that case, and we're just beginning to evaluate the contracts that they have with the fighters and other conduct that they're engaging in. And so we'll see where that takes us. But the case is basically the same theory, and the allegation will be that they've continued that theory and they've continued to restrict the ability of fighters to chart their own careers, fight for other promotions, and make more money.
Eric, I'll ask a little bit of a broader antitrust question, perhaps on behalf of not lawyers who aren't antitrust lawyers like myself. If the first case was filed in, I believe you said December 2014, how is it then that the class period extends through, I believe you said June 30th of 2017?
So we filed it in December 2014, but we took discovery, meaning the gathering of facts and information, that went through middle 2016. And we filed our motion for class certification in February of 2018. So by the time we filed our motion for class certification in February 2018, we had discovery through 2016, and so the class went through the middle of 2017. We then had a hearing on class certification in August of 2019, and the court certified the class 4 years later in August of 2023. So that's sort of the progression of the case. It took a long time to get to from the period that we filed it to the period during which we took the depositions and gathered the documents to the period where we did all the expert discovery to the class and then to the class certification and ultimately to on the brink of trial settlement. So that's the answer to that question.
Can you give us a similar timeline with respect to the second suit on where it is now and where it's been?
Yeah, so we are in the beginning stages right now in that case. We're before the same judge, Judge Liller, in the District of Nevada in Las Vegas, federal court in Las Vegas. So the case is we survived a motion to dismiss against the main defendant, Zuffa. The parent of the main defendant, Endeavor, has filed a motion to dismiss, and that's being considered right now by the judge. And we're taking discovery. So we're in the middle of exchanging documents right now in that case. I suspect that case will move much faster than the first case. I don't know how it couldn't. But in part, the parties are all educated now about where the documents are and what the issues are. The judge is very up to speed on the case and knows the facts in detail. So I think that we'll be able to move much more quickly this time, we hope, and get to a point at which class will be adjudicated in a trial date, and we'll either try the case or settle the case if we get that far.
And without trying to step on any toes or look too far into our crystal ball, if the second antitrust case ultimately results in a settlement, what type of compensation or relief do you think that the fighters might expect? Do you think it might be look rather similar to the first settlement, or do you anticipate any big differences?
So you never know. I could tell you what we're asking for. Number one, we're asking for compensation. So again, we argued in the first case that the fighters received about 20% or less of the revenues, and we showed and argued that they would have received, if the UFC hadn't violated the antitrust laws, the fighters would have received about 50% or higher of the revenues earned by the UFC from broadcasting the fights and putting on the fights. And we'll make a similar argument in the second case, that the UFC is likely paying the fighters 20% or less, but should be paying the fighters 50% or more if they weren't engaging in anti-competitive and illegal conduct, or conduct that we allege is anti-competitive and illegal. So again, we're going to be seeking damages for those claims. We'll also be seeking changes, prospective relief. I think what we want for the fighters is for them to have some measure of free agency, like you have in other sports. Right now, the contracts that they sign effectively can last years and years and years. Their careers are very short, 3, 4, 5 years at most at the top level of the sport. If a contract lasts longer than that, they've effectively locked you up for your entire career. So we're going to, what we think will help competition in the industry is if fighters could become free agents much more quickly, then other promotions could spring up, compete for the services of those fighters, and you have true competition. And maybe the UFC either would compete with those other promotions by trying to pay the fighters more, or maybe they would co-promote. UFC would promote one side of a fight, another promotion would promote the other side of the fight. The fighters would make money, the promotions would make money, and the fans would benefit from having better fights with better fighters. So we're hoping that competition between other promotions for the services of fighters will improve the sport, just like what happened in baseball, right? In baseball, you had the reserve clause early in the sport. You had a situation where players almost literally were owned by the team. They could not be traded unless the team allowed them to be traded. And so therefore they had no mobility, they had no leverage, or very little leverage, and the teams could pay them what they wanted to pay them. Once the reserve clause went away, once you had Curt Flood and others challenging the reserve clause in the restrictive contracts and you allowed free agency, fighters had mobility. Teams could compete for them. And what happened? Players' wages went from about 14% of revenues up to 50% of revenues. And did the teams go out of business? Did baseball go out of business? No. It's stronger. It's stronger because there's competition, because players are getting paid more. they're getting paid commensurate with the value that they're bringing to their sports and to the team. Better people go into the sport, you get higher quality for the fans, and it makes more money for the owners and the players. And that's what we hope to see in mixed martial arts: more competition, better quality, and higher pay for the fighters.
Eric Cramer of Burger Montague, thank you so much for joining us today, Eric. I found this an incredible conversation, and please don't be a stranger, and please come back and update us, and hopefully we can speak someday, maybe not in the too distant future, about the resolution of the second case.
Yeah, we'd be happy to talk about that or anything else you want. Good to talk to you, Matt. Enjoyed it.